50 million sold worldwide. The most popular handgun in American history, carried by police officers in every state in America, used by U.S. Customs and Border Protection as their primary sidearm. California just banned it. Not illegal Glocks, not modified Glocks, not stolen Glocks. The completely legal, factory-made, standard configuration Glock that millions of law-abiding Americans own for home defense right now. And 72 hours after Governor Newsom signed the ban, the NRA, Second Amendment Foundation, and Firearms Policy Coalition walked into federal court and said, "See you in court." I'm Sarah from GunGuidePro, 10 years in the firearms industry, and this case does not just affect California. It could set national precedent, limiting how any state in America bans firearms based on design characteristics. Stay with me through every single word, because there is a twist at the end of this story that nobody is talking about. Before we go any further, subscribe to GunGuidePro right now and turn on every single notification. We are a new channel building something genuinely important here. Real-time legal coverage for gun owners who cannot afford to be caught off guard. The preliminary injunction decision in this case could drop any day. When it does, you need to know within minutes. Every subscriber tells us this content matters and gives us the motivation to keep delivering this level of coverage for you. 2 seconds. Completely free. Hit that subscribe button. Hit that bell. Let's get into what California just did and why the courts are going to have a very hard time defending it. Let me break down exactly what Assembly Bill 1127 does, because the actual legal language reveals how broad this ban really is. The law is officially codified as California Penal Code Section 27595A. It states that licensed firearms dealers shall not sell, offer for sale, exchange, give, transfer, or deliver any, and here is the exact statutory language, semi-automatic machine gun convertible pistol. The law defines that as any semi-automatic pistol with a cruciform trigger bar that can be readily converted by hand or with common household tools into a machine gun by installing a pistol converter. In plain English, they are targeting Glock-style pistols. Glocks use this specific cruciform trigger bar design. Because of that design, California argues they can be too easily converted using a device called a Glock switch. But the ban does not stop at Glock. Smith & Wesson models built on the Glock platform, banned. Shadow Systems, banned. FMK firearms, banned. Dozens of handgun models swept in under broad language targeting one design characteristic. Governor Newsom signed AB 1127 on October 10, 2025. Beginning July 1, 2026, if you walk into any licensed gun store in California and ask for a Glock, the dealer legally cannot sell it to you. Cannot even offer it for sale. Violations carry $5,000 fines and license revocation. And here is the constitutional problem California cannot answer. Glock switches are already illegal. Converting a semi-automatic pistol to fully automatic fire is a federal felony under the National Firearms Act. It has been illegal for decades. California is not banning a criminal act. California is banning a legal firearm because someone somewhere might illegally modify it using a device that is already a crime to possess. Drop your state in the comments right now. Does your state have similar handgun restrictions or design-based bans? Are you watching this from a state that could face similar legislation next? I personally read and respond to every single comment on this channel. October 13th, 2025. 72 hours after Newsom signed AB 1127, a federal lawsuit was filed in the United States District Court for the Southern District of California. The case is Jaimes versus Bonta. Named plaintiff Danielle Jaimes, a San Diego County resident who wants to legally purchase a Glock but will be prevented from doing so when the ban takes effect. Behind her, the most powerful coalition of gun rights organizations ever assembled for a single case, the National Rifle Association, Second Amendment Foundation, Firearms Policy Coalition, a licensed California firearms dealer and its president. The lawsuit challenges the law on two constitutional grounds that are both strong and very difficult for California to answer. First, the Second Amendment. Over 500,000 Glock pistols manufactured in the United States in 2021 alone. Tens of millions in private circulation since the 1,980 seconds. These are not exotic or unusual weapons. By every possible measure, they are the definition of commonly owned arms. And under Heller 2008 and Bruen 2022, the government cannot ban arms that are in common use for lawful purposes. That is binding Supreme Court precedent. California cannot simply decree the most popular handgun in American history out of constitutional protection. Second, internal contradiction. California wrote AB 1127 as a response to illegal Glock switches, but those switches are already federal crimes. California is not addressing criminal conduct. California is banning a legal firearm because someone somewhere might illegally modify it. SAF Director of Legal Operations Bill Sachs stated it directly. Rather than heed the demands of the Second Amendment and their own courts, California lawmakers have doubled down and expanded their handgun ban. We will see them in court. California cites a 570% increase in Glock switches between 2017 and 2021, according to ATF data. Here is my question for you. Does that statistical increase justify banning the base firearm from law-abiding owners who never touched a switch and never will? Type justifies the ban or punishes law-abiding owners in the comments. I want genuine debate from this community on that specific question. Here is the part of this story that mainstream media is completely ignoring, and it is the reason this case is far bigger than a California handgun ban. The Glock G47, 5th generation Glock, not on California's approved handgun roster. California civilians cannot legally purchase it. That exact firearm, the one California civilians are banned from buying, is the primary sidearm of U.S. Customs and Border Protection, the largest federal law enforcement agency inside the Department of Homeland Security. Law enforcement in California is exempt from AB 1127. Police officers can still carry these firearms, still be issued them, still use them on duty every single day. But the law-abiding civilian who wants that exact same firearm for home defense, banned. The government carries a firearm, it simultaneously bans civilians from purchasing. Let that sink in completely. Because that is not just a policy contradiction. That is a constitutional equal protection problem. The 14th Amendment's Equal Protection Clause does not disappear when gun ownership is involved. There is also the Rena versus Bonta dimension. California is already under a separate court injunction over its handgun roster system. That case already found California's roster likely unconstitutionally bans handguns in common use. AB 1127 is California layering another ban on top of a system that is already being challenged in court as unconstitutional. That legal context makes the Jaimes versus Bonta challenge even stronger. Is it constitutional for the government to carry a firearm it simultaneously bans civilians from purchasing? Type unconstitutional double standard or law enforcement is different in the comments. This question goes to the heart of equal constitutional protection, and I want this community's honest analysis. Here is the broader legal implication that legal scholars are discussing right now, and why every gun owner in every state needs to pay attention to this case, even if you have never set foot in California. Jaimes versus Bonta is not just about Glocks. If the plaintiffs win, the ruling could set national precedent, limiting how far any state can go when banning firearms based on design characteristics. Think about what that covers. Every state that has tried to ban firearms based on how they look, what accessories they accept, what features they have, or what someone might theoretically do to modify them, all of that legislation becomes legally vulnerable under this precedent. The assault weapons bans in New York, New Jersey, Illinois, Maryland, Massachusetts, Connecticut, Hawaii that use feature-based definitions, all of them face the same constitutional argument that California is now being forced to defend. The legal principle at stake is straightforward. Can a state ban a firearm that is commonly owned by millions of law-abiding Americans for lawful purposes based on theoretical misuse by someone who might illegally modify it using a device that is already a federal crime? Under Heller and Bruen, the answer should be no. Under any honest reading of the historical tradition test, no equivalent restriction existed in 1791. The founders never banned a commonly owned firearm because someone might theoretically convert it to a different configuration. Which politician in your state do you think is most responsible for pushing design characteristic-based gun bans that target law-abiding owners rather than actual criminal conduct? Name them in the comments right now. I want to see who this community holds accountable for this kind of legislation. Here is the exact timeline every gun owner needs to know. Because July 1st, 2026 is approaching fast and the legal clock is running. October 10th, 2025, Newsom signs AB 1127. October 13th, 2025, Jaimes versus Bonta filed in federal court, 72 hours. January 1st, 2026, initial dealer provisions began going into effect. July 1st, 2026, the hard deadline. After this date, licensed dealers are completely prohibited from selling any Glock-style pistol covered under AB 1127. The critical legal question right now is whether the federal court will grant a preliminary injunction, a temporary block on the law before July 1st, 2026. A preliminary injunction requires the plaintiff to demonstrate four things: a likelihood of success on the merits, a likelihood of irreparable harm without the injunction, that the balance of hardships tips in the plaintiff's favor, and that the public interest would not be disserved by the injunction. Given Heller, given Bruen, given that California is already under court orders related to its handgun roster, given that the government's own law enforcement carries the exact firearms civilians are being banned from purchasing, the plaintiffs have a credible and genuinely strong argument on every one of those four factors. But courts move slowly. California's Attorney General Rob Bonta has made it very clear they intend to defend this law aggressively and use every procedural tool available to prevent an injunction. If an injunction is denied and the law takes effect on July 1st, California gun owners face an immediate reality where the world's most popular handgun is unavailable from any licensed dealer in the state. The secondary market impact alone would be enormous. Pre-ban Glocks and compatible platforms would spike dramatically in price, creating a two-tier system where the right to own the most common defensive handgun in America becomes a financial privilege. If an injunction is granted, it signals to courts nationwide that design characteristic bans on commonly owned firearms cannot survive constitutional scrutiny. And the national precedent radiates outward, immediately affecting handgun legislation in every restrictive state. If you were the federal judge in this case, would you grant the preliminary injunction blocking AB 1127 before July 1st? Type "grant the injunction" or "let it take effect" in the comments and tell me your legal reasoning. I want serious analysis from this community. Let me walk through the specific constitutional arguments the plaintiffs are making, because understanding the legal framework tells you exactly how strong this case actually is. Under Heller, the Supreme Court established that the Second Amendment protects arms that are in common use at the time for lawful purposes like self-defense. Glocks have been manufactured for civilian sale in America since the mid-1980s. Tens of millions are in private circulation. They are the most commonly purchased handguns in America and have been for decades. By any factual analysis, Glocks are the definition of arms in common use. California cannot manufacture an exception to Heller by pointing to illegal modification potential. Under Bruen, the court established that the government must demonstrate that a firearms restriction is consistent with the historical tradition of firearm regulation at the time of the founding. California's position requires them to find a law from 1791 or the founding era that banned a commonly owned firearm because someone might convert it to a different configuration using an aftermarket part. That historical law does not exist. It has never existed. The historical record is empty, completely empty. The conversion potential argument is also constitutionally novel in a dangerous direction. If accepted, it would allow states to ban virtually any semi-automatic firearm by arguing that someone could theoretically install an aftermarket part to modify it. That logic has no limiting principle. It would justify banning essentially any modern semi-automatic handgun under the right theoretical framing. That is not regulation. That is prohibition by creative legal argument. What is your favorite Second Amendment ruling of the last decade? Heller, McDonald, Bruen, or something more recent? Drop it in the comments and tell me why. I genuinely want to know what this community considers the most important legal victory we have seen. Here is the honest assessment of what Jaimes versus Bonta means for gun owners in states beyond California, because this is the angle most coverage is missing entirely. If the plaintiffs win a preliminary injunction before July 1st, it creates immediate legal momentum for challenging similar design-based restrictions in every other restrictive state. New York's assault weapon feature test, New Jersey's named model list, Illinois' Protect Illinois Communities Act banning dozens of platforms, Maryland's assault weapons law, Massachusetts's broad interpretation of the federal assault weapons ban that expired in 2004. All of them use design characteristic logic, similar to what California is attempting with AB 1127. If the plaintiffs ultimately win on the merits, the ruling establishes that design characteristic bans on commonly owned firearms fail both the Heller common use test and the Bruen historical tradition test. That precedent travels to every circuit court currently handling similar challenges and dramatically strengthens the legal arguments in every one of those cases. If the plaintiffs lose, California establishes that conversion potential is a valid constitutional basis for banning a commonly owned firearm. That is the precedent that every restrictive state has been hoping for, because it gives them a template to ban platforms far beyond Glocks by arguing that any semi-automatic firearm could theoretically be modified to fire differently. The stakes in this case are genuinely national. July 1st, 2026 is not just a California deadline. It is a constitutional checkpoint for the entire country. Here is your practical action plan, because knowing about this case is only valuable if you understand how to act on it. Step 1, know the July 1st deadline. If you are in California and you own a Glock or compatible platform, your ability to replace, upgrade, or purchase additional compatible firearms from a licensed dealer is going to be severely restricted after this date if the injunction is not granted. Plan accordingly within the current legal framework. Step 2, document your current ownership. If you own a Glock or compatible platform in California, keep your purchase receipts, background check records, and any other documentation proving legal acquisition. Legal transitions create enforcement gray areas, and documentation protects you. Step 3. Support the litigation. NRA, SAF, FPC. These organizations are funding Jaimes versus Bonta, and they need resources to sustain this fight through what could be years of litigation. Support them financially if you can. This case affects every gun owner in America, not just Californians. Step 4. Monitor your own state. If you live in a state with design characteristic-based restrictions, the outcome of this case directly affects how vulnerable those restrictions are. Know what legislation is being proposed in your state capital right now. Step 5. Stay informed. The injunction decision is the critical near-term milestone. GunGuidePro will cover it the second it drops. Here is the absolute bottom line. California banned the Glock, the most commonly owned handgun in American history, not because it is dangerous by itself, not because it is unusual, not because it has no lawful purpose, but because someone somewhere might illegally modify it using a device that is already a federal crime to possess. That legal logic fails the Heller test. It fails the Bruen test. It fails the equal protection test. When the government carries the exact firearm it bans civilians from purchasing. And it fails the historical tradition test because no equivalent founding-era law has ever existed. The NRA, SAF, and FPC filed suit 72 hours after Newsom signed the law. July 1st, 2026 is the hard deadline. And whatever this court decides will travel far beyond California's borders to every state with design characteristic-based gun bans. Here is what you do right now. First, subscribe to GunGuidePro and hit every notification bell immediately. We are a new channel, and every single subscriber gives us the motivation and resources to keep covering this case and every development that follows. The injunction decision could drop any day. Second, smash that like button and share this video with every gun owner you know. Most of them have no idea California just banned the world's most popular handgun or that a federal lawsuit is already fighting back. Third, answer all my questions in the comments right now. What state are you watching from? Which politician in your state is most responsible for design-based gun bans? Would you grant the injunction? And what is your favorite Second Amendment ruling of the last decade? I personally read and respond to every single comment on this channel. GunGuidePro is just getting started. This is exactly the kind of case we exist to cover. Stay informed, stay armed, stay free. I'm Sarah from GunGuidePro. See you in the next one when the injunction decision drops.